All right, I got some housekeeping issues to start off with. So Dan, you had asked me, I believe, where I got that language for the military leave, the Mount Hood contract. And then Nancy, you asked me other employees. We mentioned Dallas to do the 10-month vacation. We also have West Lynn, Wilsonville, and Centennial. No,
Hold on, I could not hear you.
So let me move this thing again, get it a little closer. I have no idea.
So vacations, I heard, whoops.
So the locations that do the 10-month are Dallas, West Lynn, Wilsonville, and Centralia. No, sorry. Centennial, sorry.
Okay, so Westland, Wilsonville is one district.
Right.
Okay.
Right.
Yeah.
Yes.
Okay.
That's
So
right.
Dallas, Westland, Wilsonville, Centennial, and
those are the three that I pulled right out of real quick for this.
okay.
I didn't go through 140 chapters, but.
All right, and then you said something at the beginning about a citation on the military leave.
Oh, Dan asked me which contract I got that language from. It was the Mount Hood contract.
It was which?
Mount Hood.
Mount Hood.
Community college?
I don't know. The rep told me Mount Hood. So
Yeah, it'd be a community college, right?
It could be. I don't know.
Okay.
I didn't get that deep detail with it.
All right.
Okay. Can you come closer and speak so everybody can hear?
Nancy?
Mm-hmm.
I also found that Schmeckett Community College does 10 and 11-month vacation days.
Okay. All right. Yeah, I guess we normally don't look at community colleges, given the fact they have somewhat different kinds of organizations and employees and calendars and so forth. So, but thank you for that information. Mm-hmm.
Absolutely. And then the only other thing was the mental health days. So in talking to some folks about this, I know we have specifically spelled out for some nurses and doctors and county workers and stuff like that. For school districts, it looks like what they've done in the areas that responded, the reps that responded to me, they've just inserted the Oregon sick leave law in there, which includes that language in it. So that's how they've handled it in other areas, is how I'm being told. So I think that's it for the housekeeping issues.
Okay.
Okay.
So do you have all of your team members present? Not seeing everybody's picture.
Who's not in there? Sorry, we moved this for the sound. Let me see if I can tweak it a little. Raise your hands, everybody, so I can see if you're on screen. Is everybody on there? What is going on with this thing? Is it catching you though?
Yeah, see it?
All right. No, I can't from this angle. Yeah.
You're very small images.
So I thought if since we didn't technically have an agenda for this, but we both knew we were coming back to do counters and TAs and stuff like that if we can. I thought maybe since we're kind of in the reverse mode you were in before, where we had lots of proposals and you only had 4, I thought we would respond to your four, and then hear your, since you have a lot more, if that makes sense.
That's fine. We have a summary of our position on all of the articles. But if you're going to give us some counters on those 4, then, you know, we would take that into account, probably take a caucus or something, and come back, maybe be able to respond to your counters.
Sure.
So I'm fine on that if you want to go ahead with your 4.
Okay, we appreciate that. Thank you for being flexible. So number 9, come on up. Let's see. Come on over. Oh, you're probably good there.
Yeah. So we took your suggestion.
Wait 1 sec. You want me to send that?
Yeah, sorry. God, I'm going to forget that every day, apparently. Please.
All right. So
send the Word document of number 9 counter.
number 9 on its
This is a
way.
new counter as of today, or
As of today.
as of today? Okay.
Yeah.
Yeah, I'm going to wait for it till it comes up then.
Yeah.
All right.
Or can you project it?
I'm sending it out now.
Okay.
Yeah. And I think Kevin's been putting them up for us to view. Very
Oh,
helpful.
okay.
All right. It is sent.
I'm going to forget that every time, apparently.
It's a fine.
Okay, I do have that now.
Okay.
Hold on, let's wait for it to be projected so everybody can see.
So this is the MOU from 9/12. And we incorporated that in our response on, I think we agreed to put it in a separate article as you proposed.
Nancy, I think, so they just sent over Article 9. So Article 9's up on the screen.
Well, I have 30 on, that was just sent over to me.
Oh, that was from me. And that was our latest one. So that was from me earlier, our last number of 30. So we're
Now
doing
it's-
Article 9
Thank you.
here.
Okay, all right.
All right, and if you scroll down, you'll see that it's largely the same proposal we had, but we did incorporate in striking written warning. And you want to talk more about that, Vance?
Yeah, we put a suggestion. Of course, we want to have that conversation with the supervisors and get that verbal warning ahead of time. So for that discussion, we went ahead and added that into the contract. I know Dan's been real good about, giving us verbal communication, and I'd like to see that go forward to all the administrators.
Okay, but up at the top in number 1, we have discipline shall include written reprimands, suspension without pay, and demotions. And then down below, I think we still have the same problem because progressive discipline is listed as conducted in the following manner. Now you've got verbal warning, written reprimand, suspension without pay, termination. So the problem we were having is that number 1 didn't match number 3A, and you substituted verbal warning for written warning. Now verbal really means written, verbal means in words. So I think you mean oral warning, but we don't see that as being disciplinary. So we didn't want it on this list at all. That was our concern.
Yeah, so
Maybe
the confusing part for me, I definitely want to make sure that verbal and written warnings are happening as in an effort to be fair with employees about our expectations. But what I would like is to make sure that we are outlining here exactly what is deemed disciplinary. I would say a verbal conversation would not be deemed disciplinary, although I always say that sometimes it feels like it. But the actual act of discipline would start with the written reprimand. Now, that does not mean that we should go right there. We should always be doing verbals and, where appropriate, verbals and some written documentation, kind of written reminders, where it's low level, but we want to nip it. So yeah, I think to what Nancy's saying there, Vance, is we'll be left with the same problem if we don't either change the definition up above or the process down below. That's what I'm trying to do, is make sure those two things are happening, are consistent.
Okay, yeah, I can understand where you're coming from with that, but we'll see what you have, and then we'll take another stab at this when we come.
When you look at our, when we get the chance to do our summary document, you'll notice that number 9, we'll do a counter proposal to your number 9 at our next session. So, and we can talk through that one more at that time too.
Okay.
All right.
So we had questions about 17. Now, we're not sending you that again because, nothing's changed from our end, because the more we looked at it, we just didn't understand. It looked like you wanted, if we understood correctly from what you proposed, you you have the exception for people in number 4, which is the designated people responding, right, to the emergency closure or whatever. And then you crossed out an essential, and we were trying to figure out, you know, what was the idea behind the and essential. Number 4 above, we understand you don't want to pay them twice, right? You don't pay for the snow day and pay them to come in. I get that, but why did we cross out an essential? We just couldn't figure that piece out.
Well,
Yeah.
the main reason there was that essential is undefined and can be different in the minds of different people. What really counts is whether the district has designated. And we do that, I think, generally in the fall of the year, so that people know before the snow season starts, particularly on, and this talks about inclement weather days. And so we might designate, you know, some couple of people who are going to come in, but maybe there are other people who are in the same job, but we won't designate them to come in because we only need one person to come in, you know, to check the boilers or whatever. So what really counts is what we've designated, and essential just adds an element of confusion to this, and that's why we struck it out.
Okay.
Yeah, the other thing is there that implies that I wanted to get out of there. All of you are essential. All of you are essential to what we do. And so I don't like that language being in there from that standpoint. And depending on the situation, we may have to designate people for a particular event, just like, like we did with food service for during the emergency closure recently. But like Nancy said, the confusion piece, and I don't like saying that some people are more essential than others because you're all essential.
Okay, so if I'm hearing it right, basically you want to be able to designate, like Nancy was saying, you might not need the full staff to come in on snow day, but you might need 3 of the 10 to come in to make sure clearing. You're trying to get to a number where you can say, hey, based on what we need, this is the staff we need. We don't need everybody. We want to designate these positions. Is that essentially what I'm hearing is correct?
Yeah, like we did. We had that meeting in the fall when we thought we were going to have a weather event, and we started off by designating the entire custodial maintenance staff, and then realized that might have been a few too many. So we designated. I think we landed at 8. So,
Yeah.
But that's the kind of approach we'd want to take there.
Okay. I understand it now, so we can better prepare our return proposal to you on that. Thank you.
Yep.
And we have that down as one we'll respond on at the next session as well.
Okay, good. All right, I appreciate that. 19. Ron's going to speak to union counter to 19.
Okay.
Is Ty going to send that over?
I am pulling it up now.
Thank you, Ty. Thank you, Michelle. Glad somebody's remembering.
All right, number 19.
19 leaves.
All right, it is going out now.
Do we have that up on the screen? I haven't gotten it yet, but that's fine.
Yeah, my internet's a little bit slower today, so it's could be a little. The squirrels are getting tired over here.
Sorry, I had to step away for a minute. Which one? Which article?
They just sent union counter number 19.
Okay.
I got it.
I guess it's hamsters, not squirrels, that run.
They're all a variation of a rat. All right, Ron, take it away.
All righty, for Article 19, we agreed to change will to may, and then we want to added your language under number 3, agreement, while maintain our position. Number 5, look at the next page.
Like he said, we basically, I highlighted, I tried to make it blue, but it kind of came off as a weird green, but when I highlighted it, but basically, yeah, we incorporated your changes into our original document and
Okay.
sent it back to you. So that's where we're at with that one.
All right.
All right, so on that one, I think that we don't have a prepared counter on that for you at this time. So we will notate that when we're ready that that we T8 on those 2 pieces then.
Yeah, the main reason we don't have a counter here is that personal leave and the increase that you propose there, you know, we view that as being part of a financial package, and we're going to still be waiting. Has anybody heard any news today about the financial report from the state?
No, been busy bargaining, sorry. But I'm sure we will hear soon.
Okay.
Yeah, I've quickly read through some of the forecasts from the Oregon Economic Office. Limited details on, you know, the impact for schools specifically. I know there's a statewide superintendent meeting this afternoon to discuss, but I believe I mean, obviously it's a dramatic decrease. I don't have the numbers in front of me in terms of where this biennium was at compared to just 3 months ago during the last forecast, and obviously down from, you know, close of session. You know, the biennium was ahead of what the close of session forecast was through the end of the last quarter, but of course now that sharply declined. But I don't believe the number is as I don't believe the whole is quite as large as what was reflected in the 17% governor comments and planning, budget reduction planning at this, you know, for the state agencies that they've been working over the last 2 or 3 weeks. I know those at COSA and OSBA were quickly working to calculate what that could mean for the state school fund, but there's a number of things that will have to be looked at by the legislature, assuming Governor Brown calls them in to rebalance the budget, specifically how much they might use the Education Stability Fund and the Rainy Day Fund, which of course it is, I think that those two funds combined, I think equate to close to 1.7 billion, if I remember right. And there are triggers and caps and all those types of things, but those are options that we didn't have back when the prolonged recession started back in, you know, in 2008. So those are a couple of things at play. We still don't know exactly what each school district will get for federal CARES Act money. And, you know, there'll obviously be some things happening over the next week or two in terms of how they decide to rebalance the budget and how much of a share of the cut that schools may bear. But the number in the official Oregon Economic Analysis report today was not as large as kind of that worst case scenario. But I mean, it's still quite severe. It's quite a severe change for a 3-month period, and obviously it's going to have some pretty material impacts into the 21-23 biennium as well, even with the recovery starting in the 3rd or 4th quarter. So so a little bit better than expected, but still a substantial difference from just 90 days ago.
Yeah, and the bill they're trying to work on now, you know, we got one version of it right at the Fed level, but we don't until they get together and figure it out. You're right. We're just up in the air trying to figure out exactly how much is going to cover different things. So I've been following that part of it as well. But so I understand for this, why you're not responding to the other part of that article that we were talking about is because of the financial impact, and that we're waiting essentially on that. Did I say that right, Dan?
Yeah. So you'll see in our summary document there a few of them that we, while not necessarily in the category of compensation or benefits, the ones that do have a financial impact, like leaves and vacations and things like that, those will all be kind of tied up in a funding, held up on funding issues. So that just kind of be prepared. Those are probably going to be the last ones we get to.
Okay.
I think, let me add one more thing. In our summary, we indicated that we would add a sentence. You raised the issue about FEMLA, OFLA, and Oregon sick time laws. And so I noted in the summary that we would be adding a sentence to that effect. I think that you had indicated that only people who had been 1 year seniority are eligible for FEMLA, OFLA, and the Oregon sick leave laws. But I believe that eligibility is dependent upon how many hours people have worked. Right. And so I just thought, rather than try to come up with a real detailed thing, we'd make the reference so people would know that that's something that they can go investigate, ask the union about, ask a business office or whatever, because some of those have different eligibility lengths of service. So we just rolled them in, and sort of in the same way that you did, but we just left the eligibility requirements unstated there according to the law.
Yeah, and that really was a first attempt to check. Really what we're running into where this is really an issue is typically people have enough compensated hours, but they're running, if they take a vacation or if they take some personal days or they have a couple sick days, all of a sudden under those regulations, they don't have enough worked hours, which the laws say, right? Uh-huh. So we're trying to address that piece because they're right on that razor's edge. So if you have a better way of doing that, absolutely, we want to see that. We are open to seeing that and figuring that out. But that's the problem we're trying to solve here. Mm-hmm. So, you get Corona for 14 days this year. Next year, you're fine. Everything's going good. And then all of a sudden, you break your leg and you got to be out. You're not getting yourself in a situation where you don't have access to family medical leave, or OFLA. And so that's really what we're looking at, trying to safeguard that stuff. Because under that example I just gave you, they'd be paid for the 2 weeks to sequester, let's say for Corona. They'd be paid for that, but they wouldn't be working. They'd be compensated, but they wouldn't be working. So that's been the biggest piece of this that I've seen. And we're trying to lower the bar a little so that we can get past that. But if you've got a better way of doing it, we absolutely want to see that. Absolutely.
Okay, I guess I'll have to investigate first whether, we obviously can't change those laws. I think what you're arguing for then would be benefits comparable to those laws, but available to people earlier or without working as much or something of that effect.
Even if we were just talking possibly about one solution of just having compensated hours instead of, those other hours, we would be able to do something like that. That's the idea. I mean, like I said, we're still in the process. You're trying to figure it out. You got our first attempt. I hear what you're saying. So it sounds like we can talk about it tomorrow a little later.
Okay.
With that, we're going to move to 23, if that's all right.
Yeah, let's do it.
All right.
All right, number 23.
Yes, Mr. Ty, please present. Oh, wait, was that Ty's?
No, I'm not presenting. I'm just confirming what I'm sending.
Right, I meant please send.
Just doing that same thing I've been doing for the last 2 days. Yeah. No big deal.
Don't worry, man. We only got about a few more days to do it, right?
Yeah. Okay, 23 is being sent now.
Yeah, you're right.
Okay, got it. Okay.
Let's wait till it gets up on the screen.
There we go.
There you go.
All right, as you can see here, that we have incorporated your language with a few changes that we proposed earlier.
And we did tweak your language just a little bit on the amount of days. As you can see there, it's the highlighted bluish green language. And we backed ours off from 1 day to 3 day to keep it in line with what we have there. So just something for you to look at. And I took your advice, Nancy. You made some good points about me crossing out temporary, some unintended consequences there. We removed that strike through. But I left it highlighted so you can see that we did that.
Okay, so I see where you've moved period from, it is currently 5. You proposed 1, now you're proposing 3 days or more. And now, are those consecutive days? I mean, if it happens once in September, once in January, and once in March, that this person is placed in a classification, in a higher classification position, does that qualify them for the pay rate for each of those days? The last day, none of those days?
You know, that's a great question. I think the thinking was that, I mean, I guess we would have to have that discussion, because if somebody's being used every Friday for this, that would be not what we intend here, I think. For them to just work their normal job 4 days a week, and then Friday they're doing this other job. But I would say the way it's currently written, it would be after the 3rd occurrence. So if you use them 3 times in a month, you know, then you would owe them for 1 day.
Mm-hmm.
The way it's currently written. But I hadn't thought of that, to be honest with you. We were trying to bring it down. Why I got rid of consecutive work days was to make it fall in line with above, where it says shall be paid their regular rate. You know, it talks about days up there. 1 to 2 days is what we changed it to. But you had 1 to 4 days. That's why I struck that, is to make, and I highlighted it showing I struck it so that you know I did it. But the idea was to keep it consistent. So, but you're right. I guess theoretically, after the 3rd occurrence, they could do that way.
I think the reason why it's written the way it is now, and we can certainly debate and bargain about the 5 days, is the idea that if you're, for instance, I think food service, probably the clearest example that I can think of is, you know, you may be chosen to move up into a head cook's position if the head cook is gone. For 1 day, you're not performing all of the duties of the head cook. You're not planning menus. You know, you're not submitting the applications for federal reimbursement or authorization or whatever. So there's significant parts of the job you would not be doing. So the question is, at what point do you start doing the whole range, the whole gamut of these higher level duties? That may vary between different kinds of positions. And so, you know, if we have to come up with one consistent number, then yeah, maybe we sort of average that out. But I think the idea is that a single day at a time, you'll probably be more like a placekeeper. You do the things to keep that part of the operation running. You know those things because you work in a job allied to that, but you don't end up doing the full range of responsibility. So just in terms of, I guess, a matter of fairness, both in comparison to the regular person there, they would probably say, well, this person is not doing the same job that I'm doing, but now they're getting paid as much as I am. Or some other people who might want that option, but are on the same level as the substitute, saying, well, that's not fair because they're not really doing anything more than they always do. They're just sitting in a different chair. So
Yeah.
that's the basic premise of that.
Yeah, and I can understand. I mean, food service, we don't really have that issue here because it's Sodexo, but I understand the general concept of what you're saying. And that, did you want to speak to that, Lisa? We have an example here that might be helpful.
I have an example comment from a survey we took that says, I don't think it's fair to put an employee in a higher paid position and not give equal pay. Example, a custodian working 4 days on maintenance 1 and lacking 1 day to avoid some pay. Wording is to work a whole week to be eligible for the same pay, work 4 days and not eligible for the same rate of pay. So a custodian would work, you'd ask them to work 4 days, and then you don't have them work that 5th day, so that they don't have to pay them that high equal pay. I see that problem with that.
Didn't you run this as the secretarial person too?
What?
Didn't you have this problem where you're working the entire classification too?
Well, I worked at one point, was secretary 1, and I got put into a secretary 2 position because an employee broke their leg and could not return to work for 2 or more months. And I feel like I immediately took that role. And I stayed in that role for 2 months or more. So I feel like when you're taking over that position immediately, and you're going to be in that position for quite some time, you should be paid immediately that way.
Mm-hmm.
I think what we're trying to get to here, Nancy, is I do think it makes a certain amount of logic what you're saying. I mean, that we're I guess one thing I would question is why they would have that person step into that role if they're not doing the job, but that's a separate discussion most likely. But even so, it's like we're trying to get around people like the 2 examples you heard where they're working for days on end, not getting the money, or they're playing the game where they're working them 4 days and then on the 5th day, we'll have you do your normal job so we don't have to pay you. We're trying to get away from that. We want this to be truly like, okay, we can't get anybody else to do this, so we're going to use our coverage. We're going to have these people working here next to them, cover them for a few days, and that's why we want, I think you're right, it comes down to a number, but I think we have to have the understanding too that, this is meant to be a stopgap, not something to be abused. And it sounds like in the recent past it has been. And that's what we're trying to get away from here. That's the problem we're trying to fix with this.
Okay.
So when we see your counter, maybe you'll have something good for us now that you know that.
Yeah, I guess I was assuming that we're talking about a situation here where we've got a person who's out for a period of time, and depending upon how long that period of time is, the person that is moved up, and oftentimes I think we do move people up as opposed to bringing in a substitute from the outside, because the person who's there, knows the nature of the work at least. So I think you're giving me a different kind of situation where there was a longer term vacancy, I guess. So there may be other articles of the contract or other provisions that apply to that. I guess I got to go look at the whole thing, but I appreciate that example, and understand the, issues that we're kind of talking about, maybe different scenarios here. Any member of my team have any questions about that?
Well, I would just like to add a couple things. I think this particular sentence or this particular section, we're trying to solve a couple different problems here, and I think that we're going to get there. We've got the issue of that we proposed where, you have a secretary, like an ed assistant moving into a secretary role because the ed assistant knows the building, knows the families that are coming in. And we don't want those folks making less than the substitute that's not our employee. So that's one aspect of this that we're trying to solve. And then we're also trying the out of a classification piece that we want to be fair on that too. And I think we're just gonna have to figure out what that number is, because Lisa's example there, it doesn't take too long before you feel like people are, it's being taken advantage of, and we don't want that. So we want to make sure that if someone's being temporarily assigned to a higher classification, like Nancy's example, okay, you go fill in maybe a day, that doesn't cover the scope of that person's responsibilities, but at what point does it? And so, this is one I know we're going to be able to solve. It just may take a little more time figuring out what feels fair.
Yeah, I agree completely. We do appreciate that you're trying to make sure your folks don't make less than an outsider that come in. We do appreciate that. We're just we figure we might as well fix it all, but we can't have a chance, right? So,
yeah.
All right, with that, we're done. Who's got no more questions with our 4 counters?
I think we're good.
All right. So we gave you this summary of our position on all articles, and there are a number of them that, we've said, well, we can't respond until we have a better financial information. And then there are some that we just aren't ready to respond. We put down next bargaining session, and I put down May, optimistically thinking there might be another date in May, but maybe it'll be June. Couple of general things. First of all, we haven't tried to make every change from association to union, but we agree to that throughout the collective bargaining agreement, and changing the plural from a singular he, she, to the plural they, their. Although the English teacher in me, the former English teacher, rebels at this, I realize that it's kind of like the time has come. So
yeah. I'm here with you.
So starting at the first, we accept your proposal on the preamble, and I think that was the one where you made some changes from association to union, and then you added PECPA at the end of the second paragraph.
Right.
So that's fine with us, and I talked with my team about how we do TAs because.
Can I interject? I wonder for those that are watching, would be the best way to have the summary document up there right now. I just want to make sure people that are watching kind of can track along with us. Do you think the summary document's the best document to have up right now?
We could put up.
So I would say yes. Yeah, that's what you're presenting, so I would say yes to that.
Yeah. Let's go ahead and Kevin, let's go ahead and throw up the summary document.
Okay. All right.
I'm having trouble finding it right now, Dan. I'm working on it.
I just sent it over about at 1:40.
Yeah.
While he's doing that, let me just ask this question again about when we TA something. I think it's probably adequate to just say, yeah, we TA it. You say, yeah, we TA your last proposal in this case. And then I think, Dan, you were suggesting that maybe we do signatures separately, having Vance sign all of the ones, and then you get those when you come in the office next and sign.
Yeah.
Actually, I think our ground rules covers this. I think we can just literally, Vance could send an email for the ones that we are TAing, and you could respond, type of thing. And the ones that are your proposals that we're TAing, you would send the email and we just respond, yes. We've done this before on other things.
Okay.
That's what our ground rules say. It might just be a lot simpler than bringing people in if they don't want to come in and deal with it.
All right, so then we'd save the.
Yeah, you just print the email or save it or whatever, yeah.
Okay. So I conclude that number 1 is TA'd because we are accepting your last proposal.
Okay.
Okay.
Yeah.
So Article 2, we do have a proposal for you, and it includes some language that we recognize came from a MOU. So we've got our, if we can put TA up there, if we can put Article 2 up there, we're proposing to keep the current contract language. For the most part, you made a change about employment up to a maximum of 90 consecutive calendar days, and you crossed off G, 3G, but we felt like that definition in 3G needs to be there. These are just definitions and help us interpret the rest of the contract. But if you look at our number 4 at the bottom, we can scroll up. So that language in red comes from a MOU that was signed. I hadn't seen it, but Dan, you had seen it in apparently 2018.
Yeah, well, upon arrival, Ron was so kind to remind me of this, or maybe it was Vance, when I had posted a temporary position and they said, wait a second there, we've got an MOU on that, Dan. And so that's how I remembered this. So yeah, so we pulled this off of the MOU and are putting it here in this recognition clause.
And there's some slight deviation from the MOU here because we wanted to clarify one thing. So temporary employees, which are defined up above in 3D, when do they become regular members of the bargaining unit? Well, this MOA was an agreement by the association and the district that if you're employed 90 days in a position within a 12-month period. And so we figured that meant a 90-day stretch. So on the 91st consecutive workday, you would become no longer a temporary employee, you'd be a regular employee. So that's the language. We added a couple of words there. I think we added the word consecutive work and in a position to clarify. We didn't think that the parties had meant that if you just work 90 sporadic days in a bunch of different positions, that qualified you to become a regular member of the workforce, but that this was sort of meant for those people who start out and we don't know if somebody's coming back from leave, let's say, so we put them in as a temporary. And then after a while, the person doesn't come back from leave, we get a resignation. When would they become a regular member? So that would be one example, I suppose. There might be others. We create a position. We don't know if we're going to need it for very long. After 90 days, if we still have that person in that position, then, we have them as a regular member of the workforce and of the bargaining unit. So that explains a couple of additional words we put in there. And then the MOU contains the second sentence, which actually sort of goes in the reduction in force language, but it talks about the fact that such employees, so these people who are temporary, then they become regular members, shall be placed in the reduction of workforce list under Article 13 at the end of the extended duration of the temporary work. So once you cross that threshold into being a regular employee, then you become placed on the reduction in force work list. When we get to that article, you'll see that we've proposed some language that will say that their seniority actually goes back to when they started that temporary assignment if it was unbroken. So in my example, we create a position, we don't know if we're going to need it, we hire somebody temporarily, then we decide, yep, maybe we hired them February 1st, and then we decide as of July 1st, we're going to make that job, or maybe it would be May 1st, whatever, 90 days. Yeah, we're going to make that job a regular part of our workforce. Then their seniority date would be February 1st, not May 1st.
Okay.
So anyway, that's our proposal. And the reason we didn't cross off G as you did is we still think that that's just a definition. It doesn't really say anything about whether anybody's in or out of the bargaining unit here. It's just a definition. So there's other language in here that talks about, who's in and who's out of the bargaining unit. That's, for the most part, was set in stone as of the time that the group was organized, which might have been in the 1970s. So, so any questions about that?
No, I think we understand what you're trying to do there, and I think that we, kind of like the last one Dan was talking about, I think we can get somewhere we need to be with this. Really what we're trying to do is keep people from being abused, and I know you guys aren't into that either, but these people that, work for, however long, and they're not being utilized the way that we intend, where if they're filling a vacancy, they should become a person that gets a job, right? So that's what we're trying to fix. We see what you're trying to do here. I think we can have some discussions in caucus and try to maybe tighten up a few things, but I think we can get there. We just got to have some discussion.
Yeah, or, certainly by the next session, because some of these things are hard to.
Yeah, fair point.
I should add that under 3D4, you propose to strike consecutive work days and substitute calendar days. And I think we told you the last time, or we had questions about that. We did not adopt that change,
Right.
because of the, the fact that that would mean that you'd have somebody maybe hired before summer break, and then they would be coming back, and their particular period of time as a temporary worker would be much shorter than somebody else's period of time, just because of the accident of when they are hired. And the whole idea here is that we, have a standard period of time that people are temporary before they become a regular member of the workforce.
Right, whether that's calendar days or work days, whatever. I think the biggest concern is that it's not 90 days stretched over a year, become full-time. That's really, I think, the bigger concern here. And we have a few different concerns. And quite frankly, if we address some of these other issues about being involved in different processes, that may take care of some of this too. So we've got a lot of ways to come at this, I think, to get something we can all live with. So.
Okay, moving on to number 3. We have a proposal there that I think just, you've added a sentence in your proposal that talks about if the parties fail to agree on a solution, they would either move the matter to expedited arbitration or economic action. And essentially our language pretty much says the same thing. We also changed may to shall. So the expedited bargaining time period under the statute is 90 days. If you don't reach agreement on a replacement for the invalid words or sections, there's all these things that happen. You can leave the language in place, nobody's agreed, but it's still invalid. So you still have to deal with the problem there if some court has struck it down or something.
Right.
But it does outline the same options that you gave, which is that the parties can mutually agree to go to arbitration, or if they don't, and we've spelled this out a little more, you said take economic action, and the economic action that the district can take under the law is to unilaterally implement its last proposal. That doesn't mean that you don't have a chance to bargain that, because every time the contract comes open, you'd have an opportunity. Your option then is that you could strike at that point. And I think that's what you told us economic action meant for you. So this is essentially just a explanation of what the law provides in this circumstance.
Okay, we understand. We understand it completely. Thank you.
Okay. 4, we didn't give you a proposal because that's an economic article.
Yep.
5, we accepted your proposal. And your proposal was to strike the fair share language, which is now illegal. And I think other than that, you only changed association to union in one place. So
Right.
I'm ready to TA that.
Okay, that sounds right.
Okay. 6, management rights. You proposed to strike all of it and added, you had one sentence, the district will have the right to invoke the grievance procedure for disputes. That really comes under the arbitration or the grievance procedure. So we didn't add that sentence, but we felt like, this language about management rights is of long standing. It's pretty basic in terms of what you see in almost every collective bargaining agreement. And we didn't see a reason to strike it, so we're just proposing to continue it as is.
Okay, we understand that.
So now under 7, we don't have a proposal ready because there's a lot of House Bill 2016 that we need to incorporate there. We just made a notice here that you proposed in Article 32 some language that the parties just TA'd in January, and it's about new employee orientation. So we just are making a notation here that rather than make that a separate article, when we give you a counter on Article 7, we'll include that language that the parties have TA'd or they've agreed to in a memorandum of understanding. We'll insert that in Article 7.
Okay, I understand.
Okay, Article 8. So here's an article, and then again, where we're pretty close. I think on the first page of the article that your proposal, there were just the changes from, to them, from him to her. The one change you made was in copying personnel files and records. And our proposal on that is that right now it says the employee shall pay for the actual cost of copying requested by the employee. So we said the employee shall pay for the actual cost of copying requested by the employee beyond 1 copy per fiscal year. We want to avoid a situation where people are asking for a copy of their personnel file every month. Believe it or not, it happens. And so we would pay for the first copy per year. Beyond that, whatever expense, nowadays we don't, if we don't give you it on paper, if we just send the personnel file over, it might be a whole lot less, but there still is some employees' time. And we're recognizing the fact people have a right to have their personnel file. They can come in and look at their personnel file more often, but if they want a copy, we'll pay for the first one per year, and then they would pay beyond that.
Okay, we understand.
Discipline, we have not gotten around to. That's a pretty involved article, so that's Article 9. Moving on to Article 10. We wanted to respond to what I think the major concern that we heard from you about this article, and that is that it governs when we have a dispute about the collective bargaining agreement. And it provides an orderly process by which that goes up from the immediate supervisor level up to the superintendent level, and ultimately on to arbitration. But you voiced a concern about lots of other kinds of things not being subject to this grievance procedure. And so what we have added here, and this is really for notice for anybody who's reading this, to the purpose section, this is the only change we've made in current contract language, is to note that complaints and concerns about issues other than alleged contract violations may be addressed pursuant to district policy regulation KLAR, and that's the general complaint procedure. It does begin with an immediate supervisor, and we put in parentheses, or assistant superintendent where the issue is not limited to one workplace.
Okay.
No point in having 3 different supervisors handle it if it's kind of a district-wide issue.
Kind of make it less of an even-handed thing that way. I agree.
Mm-hmm. So this, I think, is a way of notifying people as they are looking at this grievance procedure. Yeah, it does not cover, it covers, and its intent and purpose is to cover alleged violations of this contract, but there are other avenues. I should point out that by law, we have other policies that have their own internal complaint procedures. Sexual harassment is one of those. The federal government, US DOE, just came out with final regulations on Title IX sexual harassment law, and that governs employee to employee as well as employee to students. But that has to now by law have its own internal complaint procedure, which it does. So there are other places in our policies and in the laws for complaints that are, specially been identified. Although I would say that if somebody filed under KLAR and it wasn't the right process to be using, we would reroute them to like the sexual harassment complaint procedure. There are some very specific requirements now for districts in dealing with those kinds of complaints, so that has to be a specialized one. Anyway, so this is a way to notify people that there are other routes to pursue. And I would also, point out the fact that I think you have a practice now of meeting. I know Dan meets with officers of both associations on a regular basis. And we try to take up problems as they come up. If, they're not grievance process, they may be a different process.
Right. Yeah, the labor management, they do that when we're not bargaining, they do that monthly. That is correct.
Okay, so then 11 and 12 are ones we're going to be working on for the next session. On 13, reduction in force and recall. We have 2 proposed changes here. And I think that they relate to what we were talking about a little while ago under 1A. And we have a copy of that. Thanks. Okay, so under 1A, we made a note here that substitute or temporary assignments, right now it says shall not be considered when computing seniority, but we made an exception for that. And I gave you the example before. If somebody started work on February 1st as a temporary, and then down the road they became a regular employee, their seniority date would go back to February 1st because it was an unbroken service, and they get credit for that temporary assignment.
Yeah.
So that's in 1A. And then in 2A, I think that there was a proposed addition that we've adopted. You proposed that where it says the district reserves the right to determine positions reduced in force and will review with the union. And we're adopting that. I think there had been a change made in the next sentence in your proposal that we're not adopting. And that was the addition of by seniority. When a position to be reduced, the layoff will occur within the affected job title by seniority. Actually, it's the next paragraph, 2B, that talks about how that decision gets made. And it's a combination of a variety of factors. So, you've got current language spelling that out of how the layoff will actually occur. And so we felt like 2B is the place where that's addressed. But 2A, we agree with the concept that when we decide which positions are going to be reduced, that's kind of a multi-step process. And usually, Dan's office would be the one that would be coordinating that. Obviously, making any reduction in force is very difficult. And we're oftentimes faced with some really difficult decisions about how many positions we cut in what areas of operation. And so we are certainly willing to review that with the union, share our thinking, before that recommendation gets implemented. So we're adopting that part of your proposal. So those 2 areas we have responded to your concerns about this article.
Okay, I understand that.
Article 14, lunch and rest periods. We didn't see that you had made any change in your proposal, so we don't have any changes, so we believe that's a TA.
Yeah, I think the very top, Nancy, had the word article, which does not exist in the current agreement. So the very top of it says Article 14. In the current agreement, it just says 14.
Oh, I see. Okay.
Yeah. It's literally a technical change, but I didn't want to have anything swing by it.
Okay, well, we agreed to the addition of the word article. So.
Yeah, and then there was the word regular added.
Yeah.
Yeah, regular part-time employees, that was it.
Oh, where is this?
And I think that was a grammatical error, if I remember right.
So it's very hard for me to, when I'm looking at what I print out from your proposals, to always see where you've made a change because you're not underlining or crossing through.
Yeah, the new ones are highlighted. So that was the housekeeping batch. I didn't provide those in Word. I apologize. I didn't know it would show up that way when I sent it through. So. Okay,
so where is that change?
Well, besides article at the top, what's that?
Yeah.
It's about the middle of the page, the third sentence. Let me get to it.
Is it in the middle of number 2?
Number 3, sorry.
3, okay.
Yeah.
So workday for regular full-time and regular part-time.
Yeah.
Hours. Okay. So let me check it.
I'm trying to remember. Huh?
It was just missing before on part-time.
Okay, that's what it was. It was just missing before on the other one. I don't think it changes the meaning, but please let me know.
Yeah, but the version of the contract I got, I think off the website was, but it does have the word regular under regular full-time and regular part-time.
Oh,
That may be, yeah, maybe a typographical error somewhere on one version.
no, I was right. I thought so. It was capitalized before, so we just.
Oh, yeah, right. Okay, so we take the capital off, so, okay.
You're an ex-English teacher, you know what I'm talking about. Get it right.
Okay, so with that clarification that we add article in the title and we take the capital off the second use of the word regular in 3,
Right.
we agree to that being the new language for tentative agreement.
Okay.
All right. Vacations and holidays, those proposals are by and large economic in their impact, so we have not proposed those at this time. And we talked a little bit about 17 just a little while ago, but we felt like we need more time on that one. There are other issues that you've included in your proposal about quarantine and other health emergencies, so we haven't had time to even, consider those. So we'll just put that on the agenda next time.
Okay, yeah, we'll wait to hear back from you before we propose again. But we just to really underline the fact that we really need to have 2 processes here, one for this pandemic stuff and basically one for everything else. And as Dan can tell you, it was very frustrating, and I think we frustrated each other trying to figure this out on the fly. So I would really like to have those separated out and have 2 different processes. So we get back here again, we have something we can at least start with if it doesn't hit every point to live with.
Well, as much as we might like to see ourselves as a crystal ball balling, I would say that there's got to be a recognition of the fact that some things happen that you never anticipate, even 6 months in advance. And we don't know what will be the next unexpected. So there may be entirely different circumstances that come along. That's one of the reasons why, there is a process in the law for either party to say, we need to go back and bargain about this new unique circumstance. And that's what the parties here did. And I think you reached a tentative agreement on that MOU a couple of weeks ago. So I understand what you're saying is that you don't want these 2 to be mixed together. And we'll consider that as we do our work with this article. So then moving on to sick leave. So again, this is an article where I think we're pretty close. We have added a paragraph at the end. And this is a paragraph that we have from the licensed group's contract after the last settlement. It's number 3 here. The board will consider requests on a case-by-case basis consistent with board policy for the donation of sick leave to an employee who's exhausted his or her leave but is still ill or injured. The union member's name will be only released with prior permission from the employee. So I think that one of the strengths that we see about the donation program is that it does allow members of different bargaining units and administrators, confidentials to donate as well. If you put together a sick leave bank as you proposed, the union basically then determines the direction of those days. And so then that kind of makes separate bargaining groups, and maybe there's one for administrators or whatever, but it doesn't allow for the cross contribution really. And I think we feel and know from experience that there would be a lot of classified who might want to contribute if there was a licensed person, particularly in their building, who needed it. there are a lot of licensed people who would want to contribute to a classified person who needed days. So I think we've had prior discussions about a sick leave bank, which is your proposal. Ours is a donation program. So it's one time, then another time, then another time, but based upon, a person who has certain circumstances. There's usually a decision by the association that, yeah, this is something that we want to have go forward. The individual has to, of course, initiate it themselves. And then it's circulated, and the amount of information provided will be different in different situations. So that, you might have someone who doesn't care to have whether their name is used or not. You may have somebody who really does not want to have their name used. So that's what we've given you here, is the language that's in the licensed group. And this is a process that has been used in the past, even before it was put into the license contract. And I think that ultimately they had proposed a sick leave bank, and then they decided that a sick leave donation program would fit their needs. So that's where that came from in their contract. In addition to that, we've added some language about FEMA OFLA. I understand now your reason for putting in the 1 year. So we can go back and talk about that. But we also added some language about your concern about workers' comp, folks who are injured on the job.
Yeah.
Now, we have left in place the current language that says you can stay on unpaid leave for up to 1 year after you exhaust your available paid leave. But we've added language here that talks about employees who've been found eligible under the workers' comp law shall have the rights to reinstatement. That goes for 3 years after the date of injury or illness. It's not that you're on leave that entire time.
Right.
It's that if you recover and become eligible physically, you get a doctor's note, and you now are able to do that job, under that law, we have to find a spot for you in that same position. And that might mean laying somebody off even, but we don't hold the spot because, maybe at least 50% of the time people do not recover to the point where they're able to come back. And so it behooves the district after the 1 year of, we're holding a position for 1 year, putting mostly a temporary in there. But at that point, we'd like to be able to have a regular hire in that spot. Now, if at the end of the 3 years, the person recovers, we've got to make room for them. If we don't have another vacancy, we might end up riffing the person we brought in, but there might be somebody who came in even later who would be the one riffed. So it allows us to offer the job to someone on a little more of a permanent basis after that first year, but still preserves the rights to come back, up to 3 years for the person who is on a work-related illness or injury.
Right, and that is a big part of the concern because, they got hurt working for us. We want to make sure that they get the best chance to really recover and come back. And
Mm-hmm.
so I appreciate what you put there. We will definitely take a good hard look at that. And number 3 there, the board case by case, here's our concern, okay? One of the concerns we talked about a little bit more was that sick banks, typically how they work is, hey, if you want to join, you donate a couple days when you first start or whenever you want to join it, you put a couple days into the bank, right? And then, some of them have triggers, like if you get fall below a certain percent, because of usage or whatnot, that it triggers an additional day, something like that. But the bigger issue here, I think, is that like right now, I'm not sure you get a lot of people donating to a sick person because they're all uncertain about what's happening in the future with this Corona stuff, right? Whereas if we built up a bank for whoever to use, but we built up a bank, then we would still have the resources available, unless there was a mass run on it, we'd have resources available for people to use. That's why we were having the discussions about a bank versus the program you're talking about here. And we thought that might be something that would be more stable, and something that people can count a little bit more on, even in these kind of situations where everybody's worried about the future and whatnot. So that's just comments, so you can think about it. But we will take a look at what you have there as well.
Okay. All right, so that's 18.
Hey, Nancy, did we want to touch on, I think there might have been one thing just to maybe point out a little bit higher in the change, maybe. So just that, you had talked about the, in here in F, it was.
Oh, thank you.
You guys had crossed out at the discretion of the district, and then we did add 5 consecutive work days. So that maybe it tightened it down. It's still the may at the discretion of the district language. We're holding to that, but we did make sure that it was 5 consecutive work days and not a sporadic. So at least there's some predictability there for folks that it would take 5 days before the district would choose to do that.
Yeah, and that's you hit the nail on the head, Dan. It's one of the things that we're looking for is that consistency. So we will take a really good hard look at that as well.
That I think that moves us in that direction at least a little bit.
I think it does too.
Okay, thanks, Dan, for remembering that change. So then if we go to 19, this is one where we've already talked about the fact that the personal leave proposal would be definitely a financial issue. So we are not giving you a complete proposal, but we did indicate that our proposal will include something that refers to FEMLA, OFLA, and Oregon sick time laws. And I understand now that you're concerned about eligibility there. So we'll take a look at that when we deal with our counter proposal. I think we probably are unlikely to counter propose on this article until we have enough financial information so we can make a comprehensive financial proposal.
Okay. And one piece of it, like I said, a big chunk of it I found with some folks is just, if compensated hours, they got it covered. Work hours, not sometimes it falls short.
Okay. So then Article 20, we talked about having a proposal ready for you, but we wanted to have, I think, a little more conversation before we did that. One of the things that was pointed out is that we currently do have language in 1C that says the district agrees to budget monies for tuition and in-service programs for classified personnel. The intent of reimbursement is to ensure that a particular course or workshop upgrades the skills of the individuals or groups. Reimbursement shall not be used by a classified employee to further education or his or her, you got there, education or training for a position outside the current job role. So I heard in your proposal the fact that you wanted people to be able to access some district monies to take training that might actually either enhance their current job performance or maybe suit them or prepare them for a related job. And we're open to that idea. The one thing that I think we have to have some serious conversation about is, if we have monies budgeted in all districts that I know, if those are for classified, the biggest use of the money is for instructional assistants who want to become teachers. And while that might be a very desirable thing from the district standpoint, that may not be what the classified association, union is thinking about. So that's why I think the current one just talks about your current job role. But if it's a related kind of job, maybe the next job up in a series family, a job family, we can have some more conversation about that. We also felt that, you proposed this for technology, an additional paragraph. And I think we'd like to consider whether we need to look at that for all of our groups. We have about 65 assistants, educational assistants, and many of them also have needs for training. And we're doing a lot of that training, I understand from Dana, a lot of that training in-house, using our teachers, our psychologists, our specialists as resources. So that may work for some groups. Other groups, they're singletons, or they're people who don't have access to someone else in the organization who might have some skills or some educational training. So we need to do some more conversation, I think, before we're ready to counter propose. But that's just kind of letting you know what our thinking is. The other thing that I wanted to point out under 1A is that it does, the current language, talk about reimburse all necessary meals, lodging, and tuition, and other expenses. And so I guess our thought was that the other expenses would include, those kinds of requirements. If you have certain equipment, that the district furnish it or provide you with some sort of a stipend or something. So I guess we didn't see a need to call that out, but we'll consider whether we need to have more specific language on that. I think that's, again, part of our conversation going forward.
Yeah, and well, before I go on, Ty, did you have a comment you wanted to make on this one, Article 20?
Yes.
Survey,
a comment from our survey was actually it's from somebody who is an EA, but the comment is, I'm going to school to become a teacher, but tuition assistance is not offered to classified staff. I understand the reasoning behind that, but I do feel that it would make sense for me to be able to expand my education in certain ways with some sort of assistance, especially given that I'm an educational assistant and I help the students learn.
So that went to your broader point about training. I think that it sounds like you have some out there, but I think some of this, folks are not sure how to access it. And I think there might be a need even beyond the tech department to do some of this. I think where the tech department becomes a little bit of a unique situation to some degree is because a lot of what the certifications, like to learn Java or something, it's not something typically you can get in-house. You really do got to go out and have, like the classes and the training and all those things. And that does make them a little bit different, where they can't rely on a teacher or some mentor there to be able to get them. Because even if they could train them, they typically, unless they have the certification to do it, they can't certify them in the same way in a lot of cases. So, and
if I may, in a lot of cases when it comes to training for the other classified, we, the technology department, are doing it for the district, or helping facilitate it.
Good point. Yeah. So yeah. So we're just keep that in the back of your mind there. That's yes, I agree with your larger statement that we probably need to look at, like, more trainings. I think is a good thing, and it does make the employees more valuable to you as well. So it's a win-win. I think that there is just a little unique piece for the tech folks, where they don't have the same access to some of the stuff, or they are the person that goes through the training, so they have to get trained. The classic train the trainer situation. So we hear what you're saying on that, and we appreciate that you're giving it a lot of thought and time. And we'll be happy to see your proposal when you're ready.
Okay. Strikes and lockouts. This was one where we talked about it last time in terms of your additional language, but we felt that the statute really spells this out in very, very particular ways. We have language in the statute, as I told you last time, that says that classified employees cannot refuse to cross picket lines by any other group. As a matter of fact, if you had different groups of classified employees in different bargaining units, they couldn't refuse to cross the picket lines of another group striking. We also have language in the law that has even limitations in terms of you can't strike, you can't picket business places of board members or their homes. So there's a lot of language. And I guess what we decided there was that we would just go with our current contract language and add the words "and by PECBA" in number 1, simply because rather than spell this all out here, that gives a reference point for people to check. It is pretty complicated, and it's not just a matter of law, but there's been multiple interpretations of that law. The law was changed in '95, and then there are a slew of cases that interpreted that. And I'm sure that you would be consulting with your attorneys. So we felt like that was probably the best way to shorthand what, pointing people to the direction of, here's what you need to look at before you decide whether you're going to engage in any kind of concerted work stoppage or slowdown. So we did attempt to replicate, all of that in an article.
Yeah, and I've definitely gotten my education over the last 12 hours since we met. So I did find out that PECBA is the law that rules. The feds are out of luck. So I understand what you're saying. We will definitely have something for you on this soon.
Okay. All right. Funding, again, we'll wait until we see financial resources. On new positions, that one we've had some discussion about. We do agree to add the reference to PECBA there instead of the ORS, because people don't recognize ORS numbers, I don't think either. Yeah. In that same paragraph, there's the reference to if the duties and or level of required skill and ability of the position have changed so significantly as to constitute a new issue for bargaining, that could be a change up or down. And so I think that has an impact on whether we cross off the words may or may not be retroactive according to the agreement reached. If, for instance, we had a position and for some reason, whether it's a change in state law or change in our needs, the duties were contracted and reduced. And this language says that either party can bring that to the attention of the other and bargain over the appropriate range placement. So it could be punitive to the person who's been doing the job if that process takes, 3 or 4 months. And then there's a decision that, okay, a reduction of one range is appropriate. Then it becomes retroactive. They have to give us money back. That hardly seemed to be a good solution. So I think that's why it's always been left up to the parties themselves to negotiate retroactivity as well as the range placement. So we're staying with the same language there. Then that work out of the classification down there with the 5 days to 1, that kind of goes along with what we've already talked about here tonight. So we'll consider, you made a counter proposal to use 3 instead. We'll consider that as we come back the next time. And then you've crossed off the words temporarily there. Employees assigned to a lower classification shall continue to receive their normal pay. I think that the problem that we have there is that, we could have an employee who is going to work for us in another 20 years in a lower classification. An example of that comes to mind is that we have some people who get promoted into lead positions, and then it turns out that they're not necessarily well suited to be a lead worker. They do a fine job with responsibilities, but in terms of the extra responsibilities of being a lead worker, it just doesn't work out. And so they may be assigned to a lower classification as a demotion. They may choose to. Some employees compete for a position that is higher paid and higher classification, and they decide that that's not really what they want. And so, or the supervisor may say that's not working out, so they go back. The language with the word temporarily crossed off would mean that once they got promoted into that higher level position, even if it didn't work out for them, they would forever after be paid at the, I guess, normal pay. I don't know what normal means, but I guess it means the higher pay of the higher range. And I think that that actually might work against the idea of trying people out in a higher responsibility position if we knew that we were going to be forever required to pay them at that higher rate of pay. So that's a sort of an explanation as to why we're not crossing off the word temporarily.
Yeah, I appreciate that. I mean, you made some similar points yesterday, and we had some discussions about it. And what we were really trying to address here is where, you know, this person's out and you're the only other person that knows how to do that job, and you go over there for a couple months. So we actually, in our counter proposal, removed the strike through on temporary. I left it highlighted so you can see that we removed it, but we did remove that because we felt that you'd made some good points on that word there.
Mm-hmm. Yeah, I think that the situation you're thinking about, certainly we understand your position that we don't just move people to more responsible positions and leave them there and not pay them for it. So it looks to me like we're going to be able to work that article out pretty soon. Moving on, 24 is salary, so that's one that we're holding on. 25 on travel reimbursement and uniforms. We're staying with current contract language here because we do have language currently that says the district shall provide all special clothing, tools, and equipment required for work. And equipment, you know, could be cell phones, could be a computer. I don't know about car insurance, but in public employment or school district employment, it's never been brought to my attention that people are being told that their car insurance isn't adequate. And I think it's because, you know, the district has liability policies, and at the time that you go use your own car with permission, you know, the district, if that vehicle was involved in some sort of an accident, somebody else got injured, those kinds of liability levels, those would be covered by the district's liability insurance. Now, I don't know about the vehicle itself, but usually I think the concern that you were bringing us was probably about liability levels.
Right.
So I've never really known that to be a problem in public employment.
Okay.
That's just explanation there. So on that one, we're just going with current contract language.
Okay, before we move off that one, Nancy, Lisa had an example of, have you been reimbursed, and were you aware of that before now?
I was not aware. If it's not in the contract, I believe a lot of us don't look at the policies because there's so much there to look at. I was just stating that if something could be written in the contract, at least members would be aware that they have that option.
So when they read the word equipment, they weren't thinking about cell phones or computers or something like that, is what you're saying, right?
Probably not back in the 70s, like you said, when they got this contract together. So the car insurance piece, I'm fine with striking that. I think that's I put that in there as kind of a last minute thing to just make sure that everybody's covered. But if you've got that liability policy, like you said, that I think they are. So really, we're trying to just kind of keep it a little up to date, you know, make it clear. We're not talking about amounts or anything else. We just want to make it really clear for folks. Because I mean, Lisa's no slouch. She's been here for years, and she didn't know this policy. So
no, because I don't read the policies, which maybe that's my fault, but there's a lot to read.
Yeah, and so that's the idea behind this, is to bring awareness. So.
Right, and I can see, even though that it said equipment in the contract, maybe that didn't trigger. I mean, equipment has changed. What used to be equipment. We'll double check on that coverage level issue. I think maybe if you were a private sector employee, that might be a concern, but public sector, you know, we have certain requirements for covering our employees when they're working on our job. So liability is one of those things we have to cover.
Right, and I'm fine striking that, just, that's not even an issue. So.
Okay.
And depending on where we land on this one, you know, this would be a great topic for labor management too. Just so, because it's important that people have the devices or the tools that they need to do their jobs. And I think there's been a couple cases where Vance and Ron have brought forward concerns related to accessibility to laptops and things like that, where, you know, asking someone to do the job without, you know, access to those things, and we've tried to deploy those devices where possible. But if there's other cases where, you know, Lisa, just picking on you because you're the one that brought it up, but if you know, like, I cannot do my job without this particular device, then that you know, the district bears some responsibility to that. So you know, regardless, again, where we land on this one, a good ongoing reminder for folks of the district's responsibility to provide the tools.
Yeah, and I think that, like, we've run into situations where people are like, well, yeah, I'm using my cell phone. What do you think? They just have no idea that that would be something, because, you know, cell phones are everywhere, right? So people sometimes I don't think it enters their mind. And then we find out 3 months later or 5 months later, it's like, you know, but if they, you know, like Lisa, who looked at the contract, and 10 years later, she finds out, you know, I mean, it's, you know, it's she's, like I said, she's not a slouch. She just didn't read through all that, the policies, which I think some people don't. And so, there's a lot. So
I think some of the things that get tough, that just to, you know, kind of throw out some things that, especially with the cell phones, you know, I remember, you know, it used to be like you'd use walkie-talkies and some different things to communicate, and then devices come around and you would have people go, don't give me the walkie-talkie, just text me. Right. And there's some preference there, though, that's also some people's choices in that aspect. So there's that. The cell phone issue will probably be a tough one, a gray area there, because there are some certain aspects where the cell phone, you know, the district has issued cell phones, but then there's also people that just prefer to have their own device as to not be carrying two. So the cell phone one's probably gonna be a little bit of a sticky one, just because there's gonna be some gray on that.
Well, I would say, first of all, you have any walkie-talkies left in?
I'm not sure if we do or not. I used one as a building principal last year, so.
But I was going to say that I think the district policy, I think I did read that one, says that somebody would be reimbursed like a stipend or something if they use their personal phone. So I'm not sure it's going to be quite as a sticky thing as you might think. We more or less just want to get people aware, you know. That's really it. And like I said, I think if I recall correctly, your district does have a policy that says that they can't be reimbursed. They got to submit it though, or whatever. So not knowing that ahead of time means that they may not submit it for 6 months or 10 years or whatever. So that's the idea behind this. So
okay.
All right, well, we'll finish real quickly here because my cat is asking to be fed. And, it's getting pretty insistent here. So, contracting out, you know, we had some discussion about this last time. I think we're going to need to have further discussion and get more information. So we just didn't feel ready to respond in any specific way right now. I think what we know is that the current language sets forth the law and all of the specifics on that. But we'll have to have more conversation about some of the particular concerns that you brought up the last time. Article 27, that involves financial resources, the term of the agreement. I mean, we would like to have a 3-year agreement, but whether it's practical or doable really to come up with a financial 3-year upfront, everybody agreed upon increase is questionable in this day. So, you know, the term of the agreement is where we spell out like whether there's going to be reopeners in year 2 and 3. And so we're not ready to do that. Reclassification procedure, we need to do some more checking on that. You told us that this language was in the contract and then it was withdrawn, and we need to check that out. We agree that there is a need for some sort of a procedure to look at if jobs change, and is there a necessity for looking again at how they're placed on the salary schedule? And then there's a sort of a second issue which you've addressed, or which this old language apparently addressed, and that is, what about the person who started in a job and then has been given or assumed more and more responsibility, so they really feel like they're doing a more responsible and highly paid job? And sometimes, that's a situation where that kind of just morphs into a different level of responsibility. I think that the procedure that you proposed here has some promise to it. I mean, it probably was being used before. I do know from other experience that sometimes the resolution of that situation is that person has to be returned to the right level of responsibility. They have enjoyed taking on other tasks, perhaps, but we may already have somebody working at that higher level. So it's not just as easy as just saying, well, are you doing those higher level tasks? The question is, does the district need, let's say, 2 people doing those higher level tasks? We need a process that will address that kind of a situation, as well as, I think, some situations where the job itself changes over time. So we'll be back to you within that. Child care stipend, financial.
Before we move on, one point of clarification, then Ron's got some comments for you on the 28th here.
Okay.
This is not the old language that was originally in this.
Oh, okay.
Okay, yeah, I didn't want to give you that miss.
Okay. So you think there was an old provision, it was withdrawn at some point, and then...
Ron told me that they used to have language about 15 years ago in the contract that process dealing with this kind of stuff. It didn't work, so it got taken out of the contract. That's his recollection. I have not seen it. I do not know. This is language I picked up from somewhere else, I think another contract, of a possible process. Like I said, we really just want to, like, all the reasons you point out there were exactly right. There should be people doing what they should be doing. Some people might be working out of that classification without you knowing it, right? You don't need to do that. So I agree. This process would allow us to figure that out and to get things corrected and pick up that stack of surveys there, just to give you an idea.
Yeah.
Here's our surveys. And one of our top 5 issues, people don't know what their job titles are. They don't understand their job, or their job has changed dramatically. And to that point, I'm going to have Ron give you some of the comments we got back from them. Just
So they don't know their job title?
Yeah, they don't know. Okay, after Ron. Yeah, they don't know. Some of them don't put in. Well, I'll let him read it. So that way you're getting it directly from them.
Okay.
Okay. Here's some of the comments from our surveys about job descriptions. Since I feel my job description is vague, it doesn't include most of my related tasks, including bilingual work. Another one is, I've done job description updates 2 times, very extensive, but nothing ever came regarding changes. Would like to know how to change job titles, descriptions, and have a change made in the dark on how this process is and how it works. Long-term employees should not face probation, even if the higher classification.
Not exactly the same thing, but go ahead.
Yeah. I think it's very important to regularly update job descriptions. Jobs are always evolving, and with that evolution brings additional responsibilities that should be accounted for by pacing those. This does bring back in the economic side, but does go hand in hand. If somebody's going above and beyond their job description, it's not fair to keep them at a lower pay scale. Another one, job title change. I would be requesting a job classification. In the spring, I work at a classification I had been doing so since day 1. So I think that's pretty much it. Yeah.
All right, and then Lisa had,
Well,
Lisa has a comment about this too.
for me, my facility job started when I started doing that job. It was the first, they created that job. One person had it for me for like a year. So That was like 6 or 7 years ago. I can tell you now, this job is way different. The duties are different now than they were when they created the job.
Uh-huh.
Things need to be re-looked at.
But she has the same title and the same full job description, but it doesn't fit what she's doing. So we just wanted, we could give you a lot more examples, but we all have stuff to do today. So we just wanted to give you a flavor of what we're hearing. And so anything we can do to work on this process to make it, clear for everybody and address some of these issues, we absolutely are open to that and looking forward to seeing what you have coming back. Any further comments on this, brother? I think that's it on that one. We're going to move on to 29.
Okay. So 29, that child care stipend proposal, again, financial matter. So we're going to hold on that. The confidential employee vacancy one, you propose to include that as Article 30. Apparently, since that has been negotiated, that as a MOU, there have been a number of situations where confidential position became open and where it was returned to the bargaining unit. We're certainly willing to continue that. I guess we can put it in the contract as an article. It seems to be kind of a special process, which may have run its course, but I mean, we're not objecting to put it in the contract, and to a certain extent, maybe it's better than having a bunch of MOUs floating around. At some point, that will probably become defunct. In other words, we will have reached a point where the remaining confidential positions are ones that everybody agrees need to be confidential, and then it probably won't be an issue. But we can put it in the contract. And I think we gave you a copy of that. Then the MOU on new job position of student success coordinator, and there's an MOU that agreed to place that on salary range M, I think.
Yeah.
And so our suggestion is that when we redo the salary, schedule, and we have various jobs listed in different ranges, we just add that. We don't need to have a separate article on it.
Yeah, I think you're right on that, Nancy. I went back and looked at that and was like, okay, this is what happens when you stay up too late. So yeah, that was our intent too, is to slot it in where it belongs with the title on the job grouping and the M. That was our plan too.
Okay. Then 32, I already talked about that. When we produce a proposal on association rights, or it'll be union rights now, I guess, that will incorporate that MOU language about orientation for new hires. And then finally, you have a new article on about military. And we think that language should go into the leaves article. And so when we produce a counter on that, we'll include it. But what we've done here is sort of suggest some language that talks about temporary active duty of either a unit of the U.S. Reserve or the state military reserve. And those are so specific, dependent upon which unit it is, which conflict we might be involved in, changes around. So again, what we're proposing is just a sort of a placekeeper. I think that was kind of like what you did too, the idea that it provides notice that there is paid leave available in a lot of instances. There certainly is time off that is dictated by state and federal law. So we'll put that in the leaves article, and you'll see it there.
All right.
And I think that concludes all of the proposals.
So do you want to come back and want to give us, do we want to take a full hour to try to see if there's anything that with new information we can craft into a couple more TAs and come back in an hour and share those, and then just go for the rest of the time being caucus?
Well, it's 4 o'clock now, so we agreed that we would meet as late as 6, but I'm going to leave that up to members of my team and your team.
All right, Dan.
So why don't we take a half hour, and then maybe you can
check in.
check in, just see if you think that you have some things you could throw back our way at that point. And if you say, hey, give us another half hour, we'll send you some stuff back.
Okay.
Then we that way. If you're like, we may not get anything back your way, then we can call it. We can regroup and figure out. We definitely do not want to end today without getting another date or two on the calendar.
Absolutely.
So we'll check back in 30 minutes.
That sounds like a good plan, and we'll text you if we need any more time then, okay?
Sounds good.
All right, thank you all.
So
Is our team going to go back into our caucus, or do you want to just reconvene in a half an hour, or what's everybody's druthers here?
I have no strong preference.
Well, I figured you were gonna give us a bunch of counters, Dan.
As long as I can feed my cat here.
Yes. You don't have to choose.
You notice he was about ready to come up and take over the podium.
Yeah, that's what they do.
Why don't we convene in our Google Meet at 4:20, and we'll just kind of assess things at that point. 4:20.
Okay, thanks.
All right, thanks. Hey, so do you guys? So my team's still in the Google Meet. We're in a different room, but I'm pointing to my computer as though you can even see me. So anyhow, what do you guys want to do?
Well, we got a TA for you.
Okay.
Go ahead, Michelle.
Yeah, Dan, we're gonna go ahead and TA that number 8. Where you had the 3B, 1 copy per year, that's fine.
Okay. Is that all we're gonna do? Come back in and do, and then maybe get some more dates, or do you have more that you want to talk about?
We that's the easy stuff. We think we might be able to figure out a couple other things, but we're just going to take more than the time we have, the 30 minutes we had. So
okay.
We definitely want to get some dates before we leave here, because I can't meet in the rest of May because I'm bargaining elsewhere, with the exception of the one day I'm bargaining with you and Vance next week. I'm bargaining elsewhere, so we need to get those on the calendar so they don't get booked up.
Okay. So let me, so I'll get my other team in there. We'll TA the one. If you have any questions about, any clarifying questions, we'll do our best to answer, and then we'll just go ahead and try to get some more dates in June.
Yeah, and then we'll go into our session here to work on some more stuff.
Perfect. All right. I'm staying on the line, but I'm bringing the team over.
All right. Good news. Maybe do that again. Well, in that case, no.
You can just tell them, right?
No.
You just told them.
Kelly, is it comfortable for you?
Hmm?
Are you comfortable?
Yeah. Why?
You said your back was killing you yesterday.
Yeah, I don't know what I did. I'm gonna have to go to chiropractic. Today's one. I'm gonna try and come before I came.
Wait a minute. Go to the all natural food section. The weird place to look for something called Copperson. Look. Homeopathic and all natural. And that's what you find in the natural food section. Look for that place.
Yeah, we all need to take notes on that.
Yeah.
T-O-P-R-I-C-A-N, I think. If you look online, you'll find those.
Yes.
I could, but I thought.
Text is okay.
Yeah, I probably will do that. But if you look it up, you find it for yourself.
Pretty good stuff.
Yeah.
That's
It
like
turned me on to it, so I figured it was full of CBD or something, but it's not. It's just it's homeopathic food. Helps your body's systems work better, right? So when you rub it on and stuff like this, I blew up 3 discs in my back. Been about 15 years now, 12 years. And one of them's perforated, so that thing acts up. I put it on, it knocks it down, so I can sleep and stuff. So it is a good thing. But
That's what I got going on. What happens is that it radiates over to my hip, and then my pelvic gets all out of whack. And so then what happens is I end up.
Dan said they didn't need 2 more minutes, just by the way. I saw it in chat.
He can hear us talk about Topperson and hip pain, so.
Yeah. And I get all.
Yeah, but this helps to basically release that.
Yeah.
And a lot of times, what I'll do is like, I'll put it thick so it looks like all kind of goofy on there, you know? It's all shiny. I won't rub it close off. I'll let it set. I'll watch TV or something for an hour, let it dry, and then I'll put it on again like that. And like for really severe stuff, it really like the 3 discs in my back. You know, after doing that a couple of times, it really knocks it down to where I can see. It really brings that feeling down.
Yeah, that's.
It doesn't heal anything, like nothing like that. And like other things like I used to have after working 15 years in the warehouse, I used to have pains in my hands every day. And I started putting that stuff, but actually I rubbed it on my back and my hands stopped hurting. It's really cool.
Like,
Yeah, that's pretty good. I don't. Yeah, unless I overdo it. They have a specific version too.
What did you do? Yeah.
A cheap place to buy it though, Topperson.com.
Yeah.
Because every July and every December, I will get like free shipping. So that's usually when I just stock up. I get the big bottle, it's about $80. Another one free. And sometimes you can mix and match. You can get like 1 foot and 1 rate. But they have all kinds of ones now. But I don't know if they have a sunburn one. And they have people have like fibromyalgia and a version of that. People have sports injuries. And none of it stinks. It doesn't smell like Bengay or, you know, alcohol.
Does it have a scent at all?
I like to put the big gate on the office in case the league
You just put it on their chairs. They run around dragging their butt on the floor like a dog.
You guys gotta get that tiger balm.
That's right. Hey, you guys gotta be careful. Your man's taking notes on this. He's gonna be using this against you. He's gonna be saying, hey, you know, when Vance makes me upset, I'm gonna put some Bengay on his chair.
Damn, get worms.
Yeah, that's right. Oh, all right. Good to see Ty's cool gaming board. Nice gaming board there, Ty.
Oh, thank you. A tour, you know.
I had one just like it. I gave it to my girlfriend though. When it did away with the desktop. Desktop replacement.
I just got a big mouse pad that also has a light bar around the top, around it. So.
Oh yeah, I recognize it, man. My brother's well, he's still a pretty big gamer, but for a while there when he was in college, I was a gamer, so we could chat that way, you know. Before cell phones, they were still by the minute and stuff back then.
Yeah.
No headsets, you know. So I got into it for a bit, but I got too much shit to do now.
Internet, right, where you guys threw rocks back and forth?
I remember those days.
How old are you?
Younger than
I know, it's so shocking.
All that matters.
Rick still got his chisel and stone.
I just got another person going. They found out how old I was. They were, what? They were like 32, 35, something like that. And I was like, you thought wrong.
you can launch it, bro.
All that clean living, you know, eat fatty food, eat drugs and alcohol, it works out perfect, you know, preserves you. I'm only kidding. That was for Dan. You gotta be hearing it. You just gotta mute it so he's not laughing at it. You gonna make it?
No, that's not my neighbor's house.
Let's do that.
Thanks for CCing me on that heater stuff.
Sure. I mean, I know we won't be there for the next couple weeks.
Yeah, I'm sure. I'm thinking about coming back, sit here, so he has to come back every day and be like, oh, I lost childcare. I don't know why she has to go do what she's doing right now. No, I was just talking to my babysitter, just thinking about having kids again.
Michelle, how old are your kids?
8,
Yeah, just one.
yeah. And a 41-year-old, but.
That's her husband.
Yeah. You know, we think like that.
How are you?
All right. Sorry, guys. That took longer than it needed to.
It's all right. We're having a good old time. Did you hear us?
I had to, you guys were so loud, I had to mute you.
Oh, you missed out.
So it looks like our team is all here. So, so it sounds like we have a.
Gotta let us back in.
Hey, Drew, are you gonna turn on our cameras?
Yeah.
I think I might be able to do that.
Let's see if you can do it faster.
Oh, no, got the game.
Yeah, that's right.
I start from the bottom. You can meet in the middle.
Drew knows where the settings are faster than me.
This is the first time I've ever won.
I say you both got your excuses for losing.
I'm telling you, like, the tie is faster draw every time.
I'm still seeing that I'm not being let back in. I can't start my video because the host has stopped it.
Yeah, they're not down to you yet.
There you go.
Oh, okay.
You didn't pay the rent.
There we go.
Oh, there's almost everybody's smiling face.
Mhm.
Are we waiting for Tom? And Janet?
You don't have the controls.
There you go. Okay, right, Ty? He knows what that means. Away from keyboard. Gamer time.
All right.
I think we're all back. So Michelle wanted to let you guys know something.
Yeah, so we're going to agree to TA number 8. I almost said the wrong article. Article 8. It was pretty much already TA'd from you guys, and we just are agreeing to the 3B. So.
Once per year should be plenty.
All
Okay,
right.
so you're agreeing to TA our proposal of today on 8?
Correct.
Okay. All right.
So, can we review that ground rule on the TAing just to make sure we're kind of on the same page there? Let me pull that up. Make sure we.
I think all we added, Dan, was that the TAs will be accepted via email or something like that.
Yeah, it says tentative agreements on individual articles as they are reached will be dated and initialed by the spokespersons for each team with a copy for each team, or email affirming the TA will be allowed.
Yes.
So,
how I've been doing is if you TA'd something that we proposed, we send an email saying, you know, either multiple ones or each one saying, depending on how it happens, this is the articles we've agreed to. You know, you agreed to TA, and then you respond to that. And then anything that, like your 8 here we agreed to, you would send us that saying you agreed to our proposal 8 TA, and then we respond to that saying yes. That's how I've done it with other folks. So I don't know if that works for you. I guess we didn't talk through how exactly that would look, but that's how we've done it.
okay. Yeah, so I sent you guys 1 and 5 earlier today as TA articles. So if you want to, if we want to kind of keep with that same kind of formatting, we can, I can send you just a slightly revised Article 8, just having the same formatting. And if that suffices, then I don't know if Vance wants to respond to that email, you know, saying yes, confirmed or something like that.
Yeah, I just want to do it. If you guys just want to take on the responsibility of sending to the TAs, I guess you can do that. I don't think we have a problem with that. As we complete the articles for each completed article, we would say, yes, we TA, we're done.
Okay.
I think that's easy, unless you see a problem with that, yeah.
I don't see a problem with that. We can do that for you. You know, and while we're sort of on one thing, and meant to say it earlier while more people were watching, but we'll be getting up on our district website a link for people that will update with, so like for instance, 1, 5, and now 8 will be listed as TA'd with the changes on there, and then the ones that are still out will have either the latest counter proposal or so that people can kind of see where things are at for that. And then I will, when that goes live, I'll let you guys look at it first, just make sure you're good with it. And then when it goes live, I'll send an email out to the entire district.
Okay, and I think it might be a good idea, because I think it'll be helpful for people to have the district response proposal sheet you have that you went through us with. I think that would be a good document for people to kind of see, kind of a shorthand if they don't have all the time to go through all these articles. So they can just scroll through that real quick and see what the progress is.
Sounds good.
That'll be okay?
Yeah. So you said there were a few things you wanted to talk over, or questions or clarifications?
We also had 14 noted as ready to TA.
And 30.
Oh, yeah, the 14 and 30, are you okay with TAing those? You said you didn't really have a problem with them, other than 30 might be defunct at some point, but.
14 will be good. And 30 was, yeah, we sent over a TA for that. So yes.
Okay.
Okay.
14 and 30.
Okay. All right. Yeah, just making sure. Okay. And then, so I think that I think we're okay otherwise as we talk through some more. I think we understand where you're trying to go with some of this stuff so we can, have appropriate responses. Really, we wanted to get some dates on the book, and then we're going to use the rest of our time to caucus and rework proposals. Because my calendar, I'm sure Nancy can relate, my calendar is filling up fast with all the different chapters coming back, bargaining and different things. So I have nothing in May, but I am available starting June 1st. I have some dates.
Hey, Hobie, can I ask you in advance a quick question? I've got the 27th in the afternoon for us to bargain over some positions that we've been talking about. Are we still on for the 27th?
Yeah, to kind of wrap up all of our little separate things outside. Yeah.
Okay.
We're still on for that, yeah.
Okay, just making sure. When I heard you say you were done for May, I got worried. So
you're part of the reason I'm done for May.
Nancy, you've got that the 27th at 2 o'clock?
I have it down at noon, but 2 o'clock is fine.
I think I have noon for some reason.
Oh yeah, oh wait a minute. The webinar that I've got is 12 to 1:30, so 2 o'clock is fine. It's good.
Nope, I have 2 o'clock also. My bad.
Yeah, I was gonna say, Nancy, I can't do noon because I'm attending one of your webinars.
All right.
All right. Okay, so the starting the week of the 1st, how do we want to do this so that this is done efficiently?
Sorry, you broke. I didn't catch part of that. What are you asking me?
How do we want to coordinate our calendar so that this is done efficiently?
Well, I can tell you, efficient or not, June 1st is the first availability I have. So, don't you guys have graduation or something then too? So I don't know if that conflicts with any of that. But.
I'm available every day that week.
Okay.
So Kevin, you're a building principal. What do you have activities or things that you're tied up with?
No, not that week. I'm available all that week.
Wow, so am I. How'd that happen?
Yeah.
That's great.
I am as well. Do we want to continue with the 2 o'clock start time?
Do we want to? Yeah, I think. Well, it's kind of up to you guys. We could meet earlier certainly, but my question is, do we want to have maybe since we all have that week, do we want to do like a Tuesday, Wednesday, Thursday, like do 3 days again, like we did here? Do we think that's productive?
Thursday's graduation.
Are you graduate?
Thursday's graduation.
Oh, do these guys have work on Thursday for graduation?
That's my furlough day.
Oh, okay. So we might have to work around some furlough days, but
Yeah.
You want to do Monday, Tuesday, Wednesday again?
does that work for everybody?
Steve, Dana,
Yes.
Dana, Tom.
This would be at 2.
Do we just want to do 2 to 6?
Why don't we back it up to 1, if that's okay?
No, there's too much other things that
Okay.
I've got. That really compresses my morning meeting time. So 2's better.
All right. Yeah, that's fine.
So 2 to 6, June 1st, 2nd, and 3rd.
Right.
Yeah, and if we get some counter proposals put together before then, we might send them over before.
Okay.
I don't know, Steve, how do you feel about more information in terms of us getting financial proposals out? I mean, are we going to know?
Well, I mean, having next week to kind of help ferret some stuff out will help before we bargain again, because every day it seems like more information comes out. I think that it's hard to say exactly the timing of some of the, the forecast is out, but now we're kind of dependent on what the actions are going to be in Salem, which obviously could include calling the legislature back. So I think by that time we'll definitely know what the process might look like, but some of the decisions might still yet to be made. But we'll certainly know more, a week and a half from now than we do today, for sure.
Well, and I don't hold a lot of faith that the guys in DC and the gals in DC there are going to have their act together in a week and a half. And we're going to be relying on some of that information too. So it's up to you guys. You can put forward what you need to, obviously, but you've got ours. So you can always just counter, I suppose. But but it feels like to me that we're going to be probably talking about this towards the end of the month, if I had to guess. Because I think that's when we'll probably have these pieces to the puzzle we're all looking for. But we'll see how it goes.
Yeah, absolutely.
So with that said, do we want to add some additional dates later in June, just as placeholders in case we need them?
Yeah, I think we should try that.
Great idea, Dina.
I don't think that's a bad idea.
So I have bargaining sessions on the 9th and the 16th in McMinnville. Other than that, I'm pretty good. The third week, I'm not good after the 17th. Probably the 15th would be the best. So I don't know. We can schedule a meeting in that week.
I've got a chunk of
16th and 17th, maybe.
I was going to propose the 29th to the 30th.
Oh, yeah.
A lot of stuff really.
Sure. 23rd, 24th.
I can't vouch for my availability because I would be dependent upon remote internet service.
For which days?
23rd and 24th.
What about 29th and 30th?
I can't do it.
Yeah, I can probably be much more certain about that.
How about the 30th and the 1st?
30th of June and the 1st.
Yeah.
I'd like to put something else in between there because with those 3 days, I mean, hopefully we get a lot of language resolved, but there's a lot of language that's kind of dependent also on the economics. And I'm thinking that it might be either better on the first week in June to go Monday, Wednesday, and then put a meeting in the second week or at least at the beginning of the third week. Just because I think that if we don't have financial information very much more than we do today, it's going to be tough to make all 3 of those days productive.
Maybe we should do it this way. Maybe we should go ahead and do like a Tuesday, Wednesday, or maybe like a Monday, Wednesday for the first bout instead of 3 days. It'll give us a day in between to work on stuff if we need to. And then I have the 20th or 21st. I have 1 day open there. And then maybe come back together 20th, 29th, 2 days together, because thinking we might have financials figured by then. Would that be something that works?
I can't do it.
Or 29th and the 30th?
I'd sooner do the 1st and 3rd because I have this other bargaining on Tuesdays. Maybe they may be wanting to stick to that schedule. And then you were suggesting like a meeting somewhere in the middle of the month and then on the 30th? Yeah,
I like your idea of breaking it up Monday, Wednesday there, because that gives us a day in between to work on stuff.
Yeah.
And then instead of doing 3 days together in June, and then going down maybe like 22nd or 23rd, something like that. One of those 2 days, having another meeting, and then coming back. Maybe the 1st and the 3rd would be fine with me too, to do a more intensive bargaining. Although FYI, that is 4th of July weekend.
Mm-hmm.
Do we want to just shoot for Mondays and Wednesdays, then starting the 1st, go for those first 3 weeks in June, 1st, 3rd, 8, 10, 15, 17?
The 8th through the 12th is not going to work for me, pretty much.
Okay.
I think as long as we, The 8th is also a board meeting, budget hearing and all that. And I think that maybe, yeah, we could buy a little more time if we weren't meeting that week and Hobie's not available, but it'd be great if we could get him at least, one session in the week of the 15th and not wait till the
Yeah.
2nd.
Yeah.
Maybe the 1st and the 3rd, the 15th, and then assuming we have more to talk about because we know more of the financial picture, we could do the 30th and the 1st.
Yeah, that would work for me.
Yes, thumbs up.
You want to say those dates one more time, but that works.
The 1st, the 3rd of June, the 15th, kind of more of a check-in day, I think, and then the 30th and the 1st, the 30th of June, 1st of July.
Yeah, I may not be able to do both the 30th and the 1st. I'll just have to kind of wait and see. Or a little later in the evening might be better for me.
Yeah, and we could make that work.
Okay. I'll put a placeholder on those.
Yeah, we're hoping that we have something to talk about the 30th and the 1st, I think. So that may change too for that reason too. So.
Yeah.
Okay, let's do it. I like it.
All right.
So,
Great.
all right. Everybody goes back to their own corner now.
All right.
All right. Thank you all. Appreciate your time.